Yep. Hello, everybody, and welcome to Spin Legal. It is April the 16th, 2025, another Wednesday evening.
Yeah.
What are you doing with the weeks, Angela? You've blowing through another week.
I know. I'm starting to wonder, did I really accomplish anything? I'm wondering.
Uh, I don't know. Every person thinks about that during their entire life, don't they? I think every week we go by and we kind of go, well, on Monday morning, I wasted the time between 10 o'clock and 11 o'clock. I was sitting drinking drinks by the water
Mhm.
fountain.
Yeah.
Hmm. Nice though that was. I didn't achieve anything, right?
Yeah, my
Between
hair
10 and
was
11.
starting to get to a point where I'm starting to see a bit of the gray, so I had to put more rinse in. So,
Well, I don't really worry me about the color of your hair.
oh, that's fine.
Yeah. Okay, so you're with Spin Legal tonight. It's episode number 62, and this is April the 16th. So we're more than halfway through April. If you need to contact Invictus Legal, you can do so on 905-688-5598, or call us or email Angela at angela@weareinvictus.legal, or me at peter@weareinvictus.legal, or visit our website, which is https weareinvictus.legal. There you go. So the situation here is the court. Reason for our show today is the court has made a decision and somebody owes money.
Hmm.
Uh-oh.
Isn't that
Uh-oh.
isn't that a part of life?
Yeah. And probably at this point, you're kind of going, if you're the defendant or if you're the person, the debtor, you're kind of going, well, I wish I'd have settled for the smaller sum when they offered it to me.
Yeah. Yeah. Or you try to settle for the smallest sum when you have a settlement conference, and you might be able to get away with it in certain cases. But unfortunately, a lot of people say, I'm not guilty. I'm not going to pay anything.
Yeah.
And then what happens is it eventually gets to trial. And then once it gets to trial, a decision is made in favor of the plaintiff, and the court files an endorsement against the defendant. And short of an appeal, this can start to be enforced.
Okay. Yeah. All right. And it's the same basically broad process. The finalities might be different, but this is the same process whether you're starting your action in the small claims court or the superior court.
Yeah.
Yeah. So essentially, once a judgment is made against the debtor, that person then owes the money.
Yeah.
So there are two options here for it was the next stage. One, they're going to go to a debtor examination, or two, they're going to proceed to seizure. And just because you go to a debtor examination doesn't mean you're not going to proceed to seizure.
Yeah. And also, sometimes you know everything. You don't have to, because you know this person has this fancy new
Yeah,
vehicle that they just
exactly.
bought, or you
Yeah.
know where or
Well,
they have a house on 15 Lane, and just do a title search, and then you just pluck the seizure of land on it.
Well, exactly, because you may already know that, for example, a bank getting, a bank or a credit card company that's getting collecting on a debt against their card, the the um, the the debtor has already given that information, so they know the bank account that person has. They know that they owe that's not a nice shiny 2-year-old Mercedes Benz on the driveway at number 54, and they know that they own number 54 Maple Avenue.
Hmm. Yeah.
Right? So
So these are things that you do. And a debtor examination is best when you absolutely know nothing about this
yeah,
person. When
yeah,
you don't know where they bank, you don't know where they work,
yeah.
you don't know if the job that they have is a permanent job or whether they're just there on a contractual basis. You don't know where they live. Like, well, you may know where they live, but you don't know whether that place they have is mortgaged up or whether they're a renter. There's a number of
You
issues.
may even know that because, for example, you can do a land search on land or Terranet
Yeah, you could
to
do a
find if they
search. You
own.
could do a search and find
Yeah,
out if that person is an owner of the place. but you
Yeah.
can also own to see if there's a mortgage or other financial interests.
Yeah.
And most of the time, many times you have to get in line.
Yeah, especially if you're talking about if you're talking about a multi-million dollar amount of money that's owed, and you're talking about a debtor that is actually bankrupt, that could be true, very true.
Yeah, because if a person's bankrupt but they do own their house, you need to look at that.
Yeah,
And there could be some options there in some circumstances.
yeah.
Okay. Generally, in a bankruptcy, you generally don't have to you have to have
Well, there's still option, even
equity.
with a bankruptcy, you can
You
still
know,
see
yeah,
things.
yeah. There might be no equity in the home, or there may be equity depending on the
Well, yeah,
circumstances. But what people are doing nowadays are doing consumer proposals, so that gives you more options on secured property interests. On
yeah.
secured
Okay,
property.
let's talk about option one, the debtor examination. What is it, and how does it operate? Let's talk about what
Okay.
it
Let's
is.
say I owe you some money. So Peter just writes up the form, makes an application to the court, and he says, "Okay, I owe him $10,000, and this is the cost for me to go ahead and do all this stuff." And you apply it to the court. It has to be done properly, or else the court
Yeah,
will spit it back at you.
yeah.
And then it has to be served.
And
Okay, and then
served in
once you get
person.
a date, once you get a date for the debtor examination, then somebody has to serve it on me.
Yeah,
In
in
general,
person.
these things have to be served in person.
Yeah,
Okay. So if you're the type of person, like I might be just the type of person that kind of anticipates this, so suddenly I'm on a vacation, okay, or in a hospital, for the day that the debtor
oh,
examination.
I love that one about in the hospital.
Oh yeah, that happened
We
four
we went
times. One
we
guy.
went yeah, we were at a debtor examination a couple of weeks ago in Hamilton, and the debtor had been on an emergency appointment in hospital for the last four court appearances.
Yeah, like it's just amazing, like that he just coincidentally had to be in the hospital for those four times.
Yeah, and
Okay.
all last minute.
Yeah, all last minute. And then the
Yeah,
thing is, then of course the judge saw through that and said, okay, let's move it on to contempt.
yeah,
So they had to move it into the contempt hearing, which is
yeah,
more. I'll get into that stage in a little bit.
yeah. Well, and exactly, the contempt stuff is kind of interesting. We'll get to that.
Yeah.
So what it is basically a hearing that is there to assess what assets that you've got, what assets and liabilities you've got. It'll look at what your jobs are, what you might own. So you have to tell, and here's the interesting thing is, so you go in there, you've got 15 apartment buildings, and you tell the court about one of them. That might be enough to satisfy the debt,
Hmm.
right? The court's not necessarily going to chase for 15 of the apartment buildings that you've got, so long as the assets that are up in front of them is enough to satisfy the debt.
Yeah, like I found the apartment building and I checked it and I could put a lien on it, that sort of thing, a
Yeah,
seizure on it. So that kind of thing, like if your debt's like not very high, but if the person owes millions, there might be
yeah.
some
Oh,
legitimacy.
then of course there might well be, you might find the judge kind of pulling up his glasses and going, Mr. Jones, you can't tell me with all these 15 million that you owe the plaintiff that you only have one apartment building. I believe that you must have others.
Yeah. Or do you have this in the Cayman Islands somewhere?
Yes, quite. Now, of course, that's a good question. So something like the bank account in the Cayman Islands, is it safe?
Actually, these things, like you have these international agreements, I think they have some privacy there.
Yeah.
Yeah, because they
So
have.
it's safe to some extent.
I think they have to start changing that though, because there's a lot of tax dodgers who put things overseas and so forth. There's a lot of steps they have to take, but it's usually things like Canada Revenue or somebody like that would take those steps.
Well, I had this thing when I went to law school in England, we were doing our LLB. One of the things that the lecturer used to talk about was, oh, when the miners' strike happened, which we're talking about 83, 84, I believe, if I remember correctly, 1983 to 1984. He said, we followed the National Union of Mine Workers where all their money went around the world. And I'm thinking to myself, how can you possibly do that? But then again, I just wasn't aware of what you could do to follow said money.
There's tools. There's
right?
tools.
Yeah.
Canada Revenue has some tools too. Hey, you'd be surprised.
And the thing is, I bet, and probably so does the court.
Yeah, exactly. This is why you have to this is why they kind of make you tell on yourself and says, do you have any assets held in foreign holdings?
Yeah.
Okay. And they know you do. But if you don't disclose, then they're going to start pulling things.
Well, the interesting thing is, of course, that the lawyer or paralegal that is already asking about assets often is asking because they know already. Hey,
yeah.
We pulled the company report for your company this afternoon. Slap it in front of you and say, okay, so XYZ Corporation has, according to your website, has this exports this kind of $17 million worth of gold plate every month.
Yeah.
Right. It's like you owe us this much money. We'll take a part of that 17 million's worth of gold plate.
You get billionaires, like they're going after these people.
Yeah. The point being is that if you're facing a debtor examination, don't assume the other side doesn't know what you've got. Many of them have already done the research. If a lawyer's been involved, they probably have spent the extra money to do the research.
Yeah. And there are some private investigators who specialize in this type of work.
Exactly.
So if you're somebody that's listening and think that they can hide their assets, these people are pretty good.
Yeah.
So it's there's a lot of breadcrumbs that we leave around that we don't know about.
Exactly, and it's those breadcrumbs. So how does debtor examination operate? Because basically what we're talking about here is that you come into court, you're served. Angela, you're served. You need to appear on the 15th of May at Hamilton Superior Court, courtroom number 12. 102. Be there, right? Or you could be put in prison.
Well, actually, it doesn't start that way.
Yeah,
we have to go there, and to show up at court. Let's assume I show up. Okay, so what steps does this start with?
Yeah, basically, I'm going to be starting to question you about the assets and liabilities that you've got. So, do you have a job? Might be some of the questions. Do you have a bank account? Right? Can I have the bank at which you bank, and the branch and the account number for which you bank? Do you have other bank accounts? Right? What other loan
banks or credit unions?
Yeah. And what are exactly? So you're going through each of those.
And you have to be very clear when you ask these questions, because when you're going in there, do you have any assets held by any other financial institutions? Like there's credit unions, there's investment banks, there's the regular banks like the Big Six. So there's different things that people would need to ask, so you have to ask them correctly. And first of all, you ask, and then for each account, ask them, okay, what bank holds it? What is the address of the bank that holds it? What is the account number? And approximately at this point, how much is in that account?
Yeah. So essentially remembering that the person has been summoned to appear in the court. Therefore, when they appear and they are being asked these questions in front of the court, they're also given an oath. So they're asked to swear that what they will say will be the truth, and that failure to tell the truth could end up in what do you call it, contempt proceedings.
So, for example, like I have you there on the stand, Peter, and say you lie about everything. I don't have a job. I'm on welfare. I'm about to be kicked out of my place, so I don't even have a place to live. I'll be living out of my car, which is a 1982 jalopy. So that kind of thing,
Yeah.
Like, and then I turn around and I do some research. I said, no, this guy's lying. Hey, what you do is you get
So
them.
your question might well be of the kind of what about the 2024 Grand Am that is registered in your name?
We can do a ministry search and find out what vehicles you have. We can do we can also deal with any transactions. Like, say, if you bought a vehicle and something got disposed of relatively quickly, such as like a week before the date of the examination. Okay, so questions like that can be asked about the reasons why you disposed of it really quickly. Okay, and if you have certain bank accounts, what we did is we summoned. In one case, it's a company that claimed that they merged, or one sold to the other, or whatever, and I said, but the company that did this was the one that was the debtor. Okay, so what I did is I asked for all the back account checks, all checks and transactions, and to whom they were given. And what happened was there was some checks that the company had written, which went to the company that they merged with.
Yeah.
So all I did was ask for a motion for the court, and we added that other company to it. And I also took the checks there, and I say, okay, you paid the checks there. Why did you do this? And when you knew that you owed this much, and we were able to go after the other company because there was some money that was given to that other company from the first company that was a debtor company.
Yeah.
Okay? And it also depends on how they merged, because you can merge in different ways.
Well, and also that may actually depend upon who's doing the merging, because, for example, if you merge with the Cayman Islands company, that might be difficult to actually.
Yeah, and also whether you did it by buying up that company and then that company becomes yours, or the company bought up your company. But depending on how, because when those situations happens, that other company will take on its liabilities.
Yeah, exactly.
And
so
existing contracts, existing issues continue into the new company.
Yeah. So if Johnson and Company bought Angela Browne's company, Browne Inc., then Johnson and Company is responsible for the debts of Angela Browne Inc.
Yeah, well, it becomes the liabilities become that of Johnson and Johnson.
Yeah.
Okay? Exactly. So this is where you have to be careful, like when you're going in and deciding to buy a company. Okay?
Yeah.
And if anything is registered against a company. So if you're buying off inventory, for example, you're trying to do an asset exchange. This is why when you're buying off a company by asset as opposed to by shares, then there's something called the Bulk Sales Act, and if there's any personal property registration on the inventory, for example, that's going to become a liability for the new buyer.
Mm-hmm.
Right? Yeah. So somebody could just show up and say, "Ta-da! You owe money."
Yeah,
it's happened.
In a company buyout situation, what should have happened is that the company is actually declared all its debts, including court claims against it.
Yeah, that's why when you do buying companies, there has to be things like full disclosures, financial disclosures, and everything between the buyer and the seller, and also any kind of exchange of knowledge about the debts, a registration, and the people doing the purchase needs to look at certain databases in Ontario to see if there has been anything registered against that particular company, whether it be judgments, whether it be security interests, other types of things.
Yeah. Okay, so that's a fair question. So, so you've just sued the sued Angela Corp, and succeeded against Angela Corp. So, does the court automatically register that?
No, you have to register it, and it gets registered into different databases, and they're held by the province, not the court.
So the debtor, the creditor has to register the debt.
Like say for instance, if it's like you or I get a writ of seizure on against a piece of land, and we use that as an enforcement mechanism, and then we have to go through the sheriff, and we have to put that into the sheriff's fee, and it has to be transferred from the small claims into the sheriff's office.
Yeah, but I was just actually thinking about this situation where essentially between
that sort of thing at one time.
Yeah, so essentially between getting the judgment. So the judgment occurs, let's say, on the 1st of May. So, but of course, the judgment, you don't actually necessarily register with the sheriff right away. It might take you 5 to 10 days to do that, for example.
Well, generally what happens is usually there's a period of time in between, because you want to make sure the 30 days are cleared.
Yeah.
Just in case a party decides to file a judicial review or appeal on you.
Well, that's true as well. That's true as well. But okay, so assume your 30 days are up by the 1st of May. On the 1st of May, you know, and assume you just go into the court on the 1st of May, but the 30 days are up.
Put it in there, you file, and then you do the transfer, and it has to be registered against the property. So you have to go back to.
But there can be a time between there where at which the company is sold.
Yep, and this is why you have to be really, really careful.
Yeah.
And I don't know if they have CPLs in this country. Do you know, a CPL is a certificate of pending litigation?
Yeah, not to my knowledge.
Yeah, because I know that in BC they do, because I was reading about that the other day, about how a company, how they sort of protected themselves by putting a certificate of pending litigation, which could delay a sale if there is a sale pending until it's dealt with.
I believe that's an American thing, to my understanding.
Yeah.
I believe the British, if my memory is correct, the British also have something like that. It's not called the same thing, but there is a similar thing, and which will give you, essentially could give you some protection in 2 areas, to my knowledge. One, the equivalent of Chapter 11 type foreclosure, and the other would be for a buyout. Right,
Yeah,
because
these things you just have to make sure, because that way they're trying to prevent the person from just disappearing off the face of the earth, taking everything with them, including the car that you're about to seize and everything else.
Yeah, the challenge. Okay, and corporates are different than people, of course.
Yeah. And
because corporations
like sell a business, there's usually a sale by assets or sale by shares.
Yeah, yeah, exactly. And a corporation can be sold, at a particular time. And furthermore, the new owner of said corporation would become liable for the debts incurred.
Yeah. Again, it depends.
And again, it would again then be up to them. For example, let's say you were suing the Bay, but the Bay was sold from XYZ, from its American owners to this new Chinese lady from BC who's buying the Bay, right? She didn't know about the lawsuit, and now it would be up to then for her to sue the owner, the sellers of the Bay, to get their money back.
Yeah. And that would be quite a challenging thing, which is beyond my pay grade.
No, but that type of thing does happen within the corporate.
But it does happen. You get these disputes all the time where somebody gets into this.
Okay.
and somebody's going through Chapter 11 or different things like that, like the court has to guide people. From my understanding, it's similar to here. It's like a Division 2, or it's in companies, companies Creditors Arrangement Act, which is CCAAA, which is the act here in Canada, which is like Chapter 11.
Yeah.
And that's when they get court permission to rearrange.
Yeah, but that's basically that. Yeah. But
yeah,
that,
sometimes they go bankrupt and just sell out. Sometimes they just restructure and come back and reemerge.
yeah.
And once they reemerge from bankruptcy, many times they can come back. But it's the executives that always get the golden parachutes, I find.
We've gone to a tangent off because we talked a lot about corporate. If we took
but in most cases, when you're dealing with small claims court, yes, it could be against a corporation, but you're not going to be dealing with these situations.
But again, a corporation in a sales situation, a corporation that was sold in the middle of a small claims action, kind of the buyer's probably going to just pay it out anyway.
Yeah, this happened actually with one of my clients. He sold a property. It was in the middle of litigation, and after he finished selling it, he just paid. He just paid that,
Well, in fact, actually, there was another one
about it, because he didn't want to have the people he sold it to get mad. I guess
there was another one. There was another one where the seller actually put the money into trust for the property that they sold.
And that's quite often they do that. Hey, where they have a withholding on that, before they transfer it.
Yeah, and that withholding is held by the real estate lawyer.
Yeah, the lawyers have that, and then once the parties are done, then they just do it. Like right now, I have a costs and trust held in our thing for when we do go to court, so that just in case the other party wins, those costs will be transferred over to the other party that we've done. If they lose, then we might have some of that.
Okay, so going back to debtor examinations, etc. One important thing to note is that failure to appear can result in imprisonment.
Yep, and this is not a debtor's jail. You're not thrown in jail because you're in debt. You're thrown in jail because you failed to appear for a judgment debtor examination. This is a court order that you have to appear for.
Yeah, it's called
you're equivalent to disobeying a court order.
Yeah, it's called contempt of court.
Yeah, and then there's processes that happen within what you have to do to start working towards a contempt hearing. Yeah, and you have to explain. I give a good explanation to a judge as to why you did not attend court when you were called to do so on your judgment debtor examination.
And the intent of imprisonment in this scenario is really meant as a short, sharp shock, to sober you up and get you real that actually the debt exists. The court recognizes the debt, and if you don't now come into a debtor examination, come and actually account for your belongings, for your assets, etc., then you'll be spending more time in there.
Yeah, and you can come back, and then you can be asked or summoned back into the court to be examined. Okay, and I've had people do that. Like they've called me up. Like sometimes they leave a message like in the middle of the night on my phone. Oh, I just got put in jail. Something like that. They call me, and then I find out later on that they didn't appear for some judgment debtor examination. Yeah. And I go, you fool. I'm thinking that. When you get served with a judgment debtor examination notice, you better show up.
Yeah.
Okay? Because what happens is if somebody like us gets involved with conducting these judgment debtor examinations, we'll follow it through to the nth degree.
Yep.
And if you don't show up the next time, that might be a lead up to contempt.
Yep.
And then serve you again. Then if you still not show up or you fail to purge your contempt properly, you can be thrown in the clinker.
Yeah. And I'm working on my second contempt contempt
I threw somebody
imprisonment.
in jail too. I remember that.
Sorry?
I threw a few people in jail.
Yeah.
That's
Yeah.
because I got a person who called me. He was one of my defendants in a case.
Uh,
And so I set it up and I sent her for judgment debtor examination. I served them twice. And then by the third time I appeared up, it turned out to be a warrant of committal.
yeah.
Okay, once it becomes a warrant of committal, the court just does that. What they do is they notify your police officers all over Ontario, all over Canada, literally. They can find you and know that there's a court order against you and that it's a warrant of committal that
Actually, there's an interesting thing about that is if there's a warrant of committal out there, and let's say you spent 6 months in Mexico and you arrive back.
and that's why it goes through the Superior Court.
Yeah.
Understand it doesn't go through an Ontario court, it goes through the Superior Court so that it does have a federal implication.
Yeah.
So if I'm driving down the road and hey, my tail light is out or something like that. Hey, so the cops follow me, they notice my tail light is out. And then they run me through the system, run my plates. Ah, there's a warrant out.
Yeah.
They'll stop
Or,
me and they'll cuff me right there.
yeah. Or again, you're walking off a flight from Cancun, Mexico.
Yeah, this is
Right.
exactly what happened to
Yeah.
another client of mine.
Yeah.
And he showed up and he came in there. They wouldn't even let him out of the area. And then he had to be interviewed by a police officer. He had no idea why he was being pulled over, why he's interviewed by a police officer or anything. And they said that he's got to report to the station because he would have to report to jail. And I looked at this, I better call this people. I want to find out. Then I found out that it was a small claims court thing. And I told him, I said, oh boy. Hey. So what I did is I got a copy of the file, a complete copy of the file, and I had it brought forward. Then what I did is set aside any enforcement. And I also put it back into the court literally so that we could get rid of the prison thing,
Yeah.
So he was fine after
But
that.
Again, this only comes about because he didn't pay attention to his mail. Yes, sure, he may well have been out of the country, right? He may have been in.
What happened. He was in Colombia. This gentleman was in Colombia.
Yeah, exactly. So he may have been out of the country at the time. He may have been legitimately out of the country, but the moment he steps back in, he's in danger of being arrested.
Yep, exactly. And this is it. Or you could be it. I actually had the police knock on the door for a few of them. Okay?
Yeah.
One of mine was one of my clients, not my clients, but opposing party that was a judgment debtor. That the judgment debtor just picked up the phone and called me in a panic. Angela, why am I being charged? Why am I being arrested? Oh my God. And I said, got to pay your bills. And I said, was there a court hearing that you missed? No, that was my mom. I said, both of you are at fault. Okay? I said, the police officer is probably going to go after her too. Okay? Because the thing is, you're supposed to show up for the examination hearing.
Yeah.
So nevertheless, they spent some time in the clink and
Just as a quickie off topic, do you think that's a kind of modern day thinking is that we treat the court with contempt?
I think a lot of times there are people who do. They don't take these things seriously. That's why they have these things. That's why they have these consequences.
Yeah.
Right? It's again, this is because they are disobeying a court order, not because they're in debt or not because they are not paying off their debt. It's because they have a court order and they're disobeying it.
Yeah.
Okay, so it's a conduct related issue.
All right. Let's talk about, so you'll be asked questions if you appear at the debtor examination hearing about your assets and liabilities. So let's explore that for a moment.
Yeah. Like, for example, you'd be asked about your job if you have one, what you do, what the title of your job is, what your annual salary is, how much you get every 2 weeks, who your boss is, what is their address, what's the full proper name of the company, They'll be asking if you have any bank accounts, exactly where your money is, and if you have any other bank accounts, your account numbers, so forth. If you own any property, including your own or other properties that you rent out, or maybe jointly rent out with someone else,
Hmm.
or if you have any kind of contracts. Like if you're a contractor, like say if you're a self-employed contractor, you could be asked, who owes you money? Do you have any clients or customers that owe you money?
Yeah.
Okay, because I did this with a guy. He was refinishing a basement, and he went in there, and so I went after him. He didn't have a job. Didn't usually have he didn't have a lot of money in the bank, but he had a customer who owed him, say, like 25,000. Okay, so what I did is I had it done where I went after the customer, and the customer paid me the
Yeah.
whatever he owed me.
Yeah.
And he was very good because the customer met me at the courthouse, and then he headed up. And it was actually quite an interesting event,
Yeah.
you know. Yeah,
Yeah.
because he
Okay.
understood what
So,
that was about.
so property like real estate, like personal belongings, like for example a car. That's one of the most important things. But
Gold,
there
they
are,
want your gold,
yeah,
your
well,
jewelry.
that's why I said gold and diamonds in this list, right?
Yeah, yeah.
Now, some of these things are protected. For example, and you're not going to sell. You can't force the sale of the house that a person lives in now.
They could, they could.
It depends upon the amount of the debt. That's for sure. They could
Like
force
I've
the
had
sale of the debt.
somebody who had his own house, and it was put in for seizure and sale, and he guy did it, took the time, and he sold it.
Yeah,
Okay. Naturally, the guy was able to remortgage it and buy it back, but it was a very harrowing experience for him.
yeah. But again, typically, if you owe $5,000, writ of seizure and sale is probably not going to apply.
You could, like this guy had $10,000 he allegedly owed him, and then this guy did this. He pulled
Mm.
off the naughty, and he
Yeah,
did this. And I said, "Oh my God!"
yeah,
I was very shocked that somebody would actually do that, but it's very expensive to do that.
yeah.
In 99% of the cases, it's just not worth it
Well,
unless
you
it's a
you've talked
substantial amount of money.
you've talked about seizing cars and things like that.
Oh yeah, seizing cars is interesting because the person wakes up and their car's gone,
Yeah,
right? And they wonder
and
why, except with a bunch of papers in their mailbox.
and for certainly for a larger debt, seizing real estate, especially if you're talking about investment properties, like a um, a tenanted apartment building.
Yeah,
If the person that has, let's say, 18 apartments in it, that might well be something that could be seized and sold if it was
yeah,
a large
that's
amount
another
that was
one that
owed.
could be. And the thing is, too, I mean, you just have to kind of use your common sense. Most of the time when we do it, we put a writ of lands. You put a writ of seizure of land onto the property. Even if we use other methods of enforcement, we might go to a judgment debtor examination, we might go to a garnishment of wages,
Yeah,
might go to different things, but we have a writ of seizure of the property on there just in case they are soon to renew their mortgage.
yeah,
Because what happens is they do this and then they send all the stuff there. We do a statement. There's an affidavit that's put in there, and then it gets sent there to release the lien, and that money must be paid to their real estate lawyer or whatever, and then that money gets sent to the creditor.
and and just to cover that one, of course, is that typically, of course, in Canada, given that you've got an amortization over 5 years for most of your mortgages, you're typically coming back to the bank every 5 years for a remortgage. So at any typical time, like right now, if I want to do a writ to seizure of seizure and sale, I'm typically about 2.5 years away from having that money come back,
Mm-hmm. Yeah,
right?
yeah.
Whilst you
See
have to
how long
renew it.
it is, or a person may want to say, okay, I want to I just got so much far in debt, so I'm going to restructure my mortgage.
Yeah.
Something like that happens.
Yeah.
A lot of people are doing that because
and provided
yeah.
And provided the debt is registered, the money will get paid.
Yeah, it'll get paid because you owe 140,000 in debt, but you also have a debt registered for 20,000. So they come up with 160,000, right?
Yeah.
To put your mortgage there. That lien gets released and the money goes back to the creditor and any costs that might be attached to that.
Yeah.
And then that gets to be a higher mortgage, even though your mortgage may have been intended to be 140.
Yeah. Okay. The other question we talked about, and we talked about this last week, was garnishment. So if you've got a job or you've got assets like rental property, you can garnish wages, or you could garnish actually rents, for example.
Yeah, you can garnish your tenants, right?
Yeah.
Because I've done it before once. Okay.
Yeah.
I've done it once. And the person that was the landlord of that property, like they find out relatively quickly. And
I'm not surprised.
And they do act on it real fast.
I mean, if you owe $30,000 and you've got a 100-unit apartment, and I'm now going to units 1, 2, 3, 4, 5, 6, 7, 8, 9, and 10 to get my $30,000.
Mm-hmm. Yeah. So
you're going to know about it mighty quick.
Yep. Right. And it may not necessarily make you very happy, but too bad. And you can't do anything to those tenants, right? Because generally they're notified that that this is something that is a court order and you need to give it this way. Yeah. And then those tenants get a receipt for payment.
Yeah. And the point being is that
let them know, okay? And the landlord can get the receipt from them.
And once the appropriate amount of money is taken from the relevant number of tenants, the rest of it continues on to the landlord.
Yeah, exactly.
If he's got 100-unit apartment building, and you only need to garnish 10 tenants to actually make the money.
Yeah.
You take the 10 tenants.
Because that would go through a disclosure process when you have an examination, for example. The person said Joe Jones is unit 101 and he pays $2,000 a month. Peter Smith lives in unit 103. He pays $2,400 a month. So here you are, you're writing all this down and you have a sheet of paper with all this stuff. And then you just serve these people notices of garnishment. Unfortunately, though, you have to have a garnishment for each person. So that's $144 for each person for a small claims court. Okay? It's more expensive for a superior court. But for each person, it's a new garnishment. So that's why it's not done very often. Okay? But in a way, but it is something that to use that it's just absolutely, it's something you can guarantee a quick reaction to.
but in a way, if, for example, as I said, you're garnishing 10 of those 100 apartments, you've got your debt paid in those 10 apartments.
Yeah,
right? It's done.
Yeah, and this is how we do it. There's okay, so this is one of the things that we do, and also too in terms of garnishing or seizing objects or seizing assets. There is something called the Execution Act in Ontario. Well, and it also applies to things like bankruptcy too.
Before we get into seizure, let's just remind everybody that garnishment is about taking the money.
Yeah, seizure, it's a money issue, and the asset is seizing the asset to convert it to money.
Yeah. Seizure is about where seizure of assets can be done with or without a debtor examination. Now, getting on to the second part of this. And seizure is about taking assets that, as you say, can be converted into money.
Yeah.
For example,
you find your car missing.
For example, your BMW car that's worth $35,000 can be sold to settle your $25,000 small claims debt, and the other $10,000 can be given back to the car owner.
Yeah, because that's what generally happens. All the costs and everything over and above. because there's court costs, there's bailiff costs, and other types of costs, even holding costs when you have them in the impound.
Yeah.
So there's lots of different costs that are involved with that.
Well,
And
that's
then
an
once
interesting
that's,
fact.
yeah,
Yeah,
and
that's
then
an
once all
interesting fact.
that's dead and gone, and if you get more money than what all the costs are in total, any balance is returned to the debtor.
Yeah, I was going to say that that car that I said was that you sold for
I can write you a check
35,000.
for 50 cents after all of that is done.
Yeah, exactly. The car you sold for 30,000, 25 goes to the person you owe they owed the money to. 9,995.50 goes to goes to all the other
Yeah, the costs and bailiff, all this stuff. Generally, it goes back to the council or to the person who acted and paid
yeah,
all those costs.
yeah,
So they get that. So that because when you're paying the bailiff, you got to pay them up front. You got to pay the courts up front. You
yeah.
got to pay for these
Oh, yeah.
things. So when the asset is sold, all of this is added on top of all the costs. And when the asset is sold, you get repaid all of those costs plus the debt, that's owed to you. Right? And
So that
then
might
the
actually,
debtor might get 50 cents left, or they may get a few $1,000s, depending on how much was owed and how much the value of the asset. Okay?
yeah.
And this is all done carefully, and these processes are carefully recorded so that the debtor, when they get their stuff down, they know exactly how much was paid for what. So
Yeah.
so it isn't somebody just trying to scam them and say, "Oh, this is all about costs and everything else,"
Well, actually, exactly that. Everything has to be recorded. There's a
Yeah,
whole
and there's
count.
regulations about how much could be charged for things.
Yeah, exactly.
Yeah,
And for example, the cost of the bailiff taking the car is a fixed cost that is then paid by the creditor,
yeah,
the creditor's lawyer or whatever,
hmm
typically by the creditor. So that is so. For example, if I'm saying the bailiff's cost is 2,976, right? That gets added to the debt. So now
yeah,
your 25,000 is 27,296.
yeah. And then there's court costs. You have to
Yeah,
file for the writ of seizure. You have to, and then there's a whole lot of stuff. And then you actually go back to sale, of it. And there's a days for impound, and just
yeah,
taking it away from you because you got to put it somewhere before you sell it.
yeah. Oh yeah,
And there's a number of acts that apply to that and legislation. But one of the things that's very important to, like, say if you have a small business or a trade, the tools of the trade cannot be taken.
yeah.
They cannot, I think that there's a dollar limit of what they can take from you. They have to leave you with X number of things like your furniture and stuff like that that are things that you use day to day.
So,
Uh,
for example, a work computer couldn't be
No,
taken.
no, they can't.
Yeah,
Because the thing is, let's take away a person's means of making money.
yeah,
So that's like killing the goose that lays the golden eggs.
yeah. And again, likewise, you cannot take away a car that is not finance free.
Yeah.
If the bank owns the car, and that's the wrong way of saying it,
So
but
you got the other way around. If the bank is financing it, then it's going to be very difficult for you to take it because there's a loan on it. If it's something that you own free and clear, then it can be.
yeah, Leon, you're in the middle of the show. Yeah,
Okay.
yeah, okay. Right, we'll call you back after. Okay, fine. Our friend called.
Oh, okay. So we'll call them back.
We'll call him back afterwards, right?
Okay, sure.
Yeah. Okay, so a writ of seizure and sale of land. We were talking about this. When the debtor sells the land, the debt is enforced, right?
Yeah, exactly. They cannot allow the sale to transfer or go through
Yeah. And
until it's paid off.
typically, as you say, with any of these writs of seizure and sale of land, they have to be renewed every 6 years.
Yeah.
But typically, I think most Canadians tend to buy houses about every 6 years, buy and sell new homes every 6 years. I think you and I are the exception to this one, Paul.
Yeah, it's just because I'm lazy.
Yeah. Well, I'm satisfied with where I am right now. I made a good purchase.
I would be.
I made a good purchase, and hey,
I'd like to get another house.
You never know but you never know what the future may hold, right?
Yeah, exactly.
Right? But the point being is that, for example, so if you're a typical person, you're selling your house in after 5 or 6 years, right? So when there's a writ of seizure and sale of the land on it, so that may well be that, okay, so if you're talking about 6 years, you're halfway through the cycle, you're at a 3-year thing before you come to the point at which you're going to sell. So now, as I owe Angela $30,000, my lawyer goes, ding, 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 ding. Got a problem here. You've got to give Angela money. Right?
Yeah. Because there's a lien on your property.
Yeah.
You know, we got to deal with it.
Okay. So the other question is, if there's a mortgage on the property, that same thing happens.
It's also is released too, because the mortgage gets discharged. The term is discharged. Right?
Yeah. But if I own the property free and clear, and I never sell it,
that's when people start using the big sticks.
And my son, and essentially my son in 30 years' time becomes my heir. Right? There's not any sale goes on here, is there?
No.
Right? So how would you enforce the debt that way?
Well, generally, as I said, they get renewed. And you can also just, as I said, you could take procedures to force sale of the land, which can happen.
So essentially what you were saying is...
You're first in line. You're first in line, and you can do that.
Yeah.
Okay.
Well, actually, first in
line... I mean, you can't just do that unless somebody defaults on it. That's a different situation, because they're protected. Like, as long as you keep paying your mortgage, it's not going to happen to you.
You're not in the case where you're free and clear. You're not first in line. The debtor isn't first in line. The city is always first in line.
Yeah. Jeez. I don't like this.
Yeah. So the debtor is always first in line, right?
Yeah.
Okay.
Yeah, exactly. So this is what happens.
Like, for example, if you owe property tax, the city would be first in line.
Oh, yeah, the city, yes, definitely.
He is always going to be first in line.
Yeah, because the city likes to do that because they're very important.
Yeah.
They're very important people.
Justin O'Donnell, WhatsApp audio.
Yeah. Okay. So that's about first in line. Then the next question is that, so it can be enforced, but it's slow. Right? That's the point.
Yeah. Right? It doesn't happen very often when they do this, but it does happen periodically. If you go through a newspaper, sometimes you'll say, sheriff's notice for sale of land. Okay? And people wanting to go in and they do a bid.
Okay,
Part of that is because of lawsuits.
We talked about land here, and obviously that's the biggest asset to go for. And I think you wouldn't normally do a sale. You know, if you're chasing a $5,000 debt, notwithstanding that you said, yes, you know somebody who's done it.
$10,000 debt, but still, like as soon as I found out that the guy was doing this and actually carrying on with this, and I said, you're nuts.
Yeah. Typically you wouldn't force a sale, but you might seize products and inventory that the person owns, right?
Seizure of property, and often that's usually something that's attached if they got a loan to start a business or something. You set up a store, and in your inventory, you put on a PPSA loan.
Yep. Okay.
General Security Agreement, a GSA, they call it.
Yeah. And the point being is that that's quite an important aspect there. Okay. And the other thing is products and inventory, right? For example, if you're taking an action, say you're taking an action against Walmart or I don't know, Home Depot, for example, right? Home Depot's kind of got quite a large inventory of products in the store, haven't they?
Then I could go in there and say, "See, I got this, and I'm going to go walk in and take up all of these items."
I want the most expensive drill in the store.
I don't think it happens that way, but however,
No. Yeah.
You can imagine, right? You can only
No, I
dream.
know.
Would you
I know.
like a nice shopping spree at Home Depot? I'm sure you would.
It's good to joke about it, but in fact, actually, you're right. It doesn't happen that way. Essentially, if you're going to be seizing inventory from Home Depot, it'll be, you won't be seizing it for home.
Generally, in general terms, when I've ever went after larger companies, and they either lost a lawsuit or they defaulted, we get paid.
Yeah,
the company just coughs it up.
They cough the check up. They do it
because they got legal departments.
But again, instead of I said Home Depot, you're talking about little bitty hardware store. The inventory of that might well become an asset.
It could be, yeah. You can put some things on it. You go in there and you can put some attachment on certain items.
Yeah.
Okay? But But as I said, it just doesn't happen where you can just wave a paper in front of someone and walk in and take what you want.
No. It has to be done. It has to be done again through accredited people, doesn't it?
Yeah, it has to be done through the courts and
Yeah.
through the process and through a bailiff.
Yeah, exactly. So a bailiff it's the bailiff that's actually going to be taking the property.
Yeah.
Yeah. Okay. So that's been a kind of interesting rundown about where we are with enforcement, other types of enforcement, because we covered garnishment last week, so we covered other types today.
Yep, exactly. Right. So these are different things. Like I just said, there's other types, which is a little more complicated, like writ of delivery, things like that. And so you just have to kind of, as we go along, and these are things we have to look at. So anyways, if this is something that you're looking to enforce a debt, we do that.
Yeah, absolutely. So if you need to do that or need to contact us anyway about any legal issues.
Something you're worried about, or you're being sued yourself.
Yeah. Right? You can call us on 905-688-5598 or email Angela at weareinvictus.legal or me at peter@weareinvictus.legal. Or you can go to our website, weareinvictus.legal, and contact us from there. And now, this is Angela's favorite part of the show.
Oh, yes. So what you heard today on Spin Legal, whether in this show or in others in the series, is not legal advice. We do not give legal advice on the air in podcasts. So don't go around telling somebody, well, I heard this on this podcast, so therefore it must be true. No.
And it's not true even on Facebook.
Information we hold to the public as a public interest. Because every situation, even if it looks the same as yours, is not the same as yours. Yeah. Okay, so that's why you need to come up and talk to a legal person, like a paralegal or a lawyer. Yourself, we'd like you to come here and talk to us, but as I said, it's better to get your own legal advice and find out what you can do about it, or if you can do anything about it. And then steps are suggested, and then see what happens.
Yeah. Okay. And have a great week, and we'll see you this time next week, I guess.
Yep, exactly.
All right. Bye.